My name is Miranda Lindl O'Connell, and my title is partner in private investment funds at Morgan Lewis.
My name is Bob Cooney, and I am a senior vice president and the general counsel at LISC, which stands for Local Initiative Support Corporation.
The name of the Grunin Prize nominated project is the Black Economic Development Fund,
which we generally call the BED Fund. Well, the problem that this fund was trying to solve, in short, was to create access to Black-owned businesses, Black entrepreneurs, Black-led anchor institutions, to get better access to credit and to get access to credit on better terms, right? So LISC has been investing in low and moderate income communities across the country, both in urban areas and in rural areas for a long time. And we're constantly looking for new ways to deploy capital into those communities. And in response to, not just in response to current events, but partially in response to current events, and everyone's increasing awareness, even though I'd say at LISC we've been aware of this for a long time, of the problems with racial wealth gaps and racial equity generally. We felt like the moment was right to introduce a fund that's targeting the Black-owned businesses and institutions I mentioned, and to try to make sure that they're getting the access to credit that they should, so that they're in a position comparable to, white-owned businesses, which all too often is not the case.
I would just add also that the problem that the project was trying to solve as well was addressing more of the systemic suppression and exclusion of Black communities from access to that financing. And both based on their own experience as well as a lot of research and data, LISC was trying to be creative about how to access new sources of capital to be able to do that. And using their extensive experience in investing and lending to Black communities and sources of capital for Black entrepreneurs, they were able to come up with a product that was particularly attractive to a new set and new type of investor that hadn't been as predominant in the field of impact investing. So the solution that the project created was to increase the quantity and quality of financing available to Black-led financial institutions. So the purpose of the fund was to empower the Black American community by strengthening the Black-led financial system. And rather than position its strategy as a traditional impact investment, the BED Fund connected the corporate treasurers of public companies and presented what we call an impact treasury strategy to meet the particular needs of the treasuries of publicly traded companies. Those needs being capital preservation, investment duration, and risk tolerance of certain corporate treasuries that aren't consistent with more of the investment side arm of the companies. This kind of innovative way of approaching being able to attract capital from these larger companies also provided them the opportunity to have impact to Black communities. And so in the end, what came out was this kind of hybrid fund offering that attracted a new type of capital and investment participation that hasn't been as prevalent in the impact fund market. And I'll just also speak a bit about how they were intending to deploy the capital once it was raised. Is the BED Fund, uses a combination of different types of financing, short-term, medium-term. They target different types of actors in the finance markets that are able to easily deploy the funds to Black communities. So these include Black-led financial institutions, anchor institutions. They also participated in co-invest alongside Black-led banks, credit unions, and other CDFIs, community development financial institutions. And then they also focus, and this helped with the attracting capital from kind of the unique sources of investors, is they also allocate capital to highly liquid FDIC insured deposits and products at Black banks, again, to facilitate an increased deployment to the Black community.
I would add to what Miranda already said that, you know, an exciting part of this for us was being able to pool a like-minded group of investors who are interested in achieving impact and who are willing to consider creative ways to do it. So I give a lot of credit to the investors in the fund who took their treasury dollars and, you know, realized that by taking a small percentage from their treasury dollars and investing it into a fund with a specific mandate, that they could accomplish their treasury objectives and also achieve impact. And that was an exciting development, and it's an avenue that I think hopefully, or that I hope LISC and others will explore further with the investors of the world, because they can really create the impact by being creative.
So the lawyer's role in advancing the solution took many forms, and you know, the lawyers were involved from the very beginning in trying to create the structure to accommodate the different types of investors going in, as well as the nature of the investments. In particular, in the beginning, it was a large focus on terms and helping just to kind of finalize the more hybrid nature of the form of investment this was going to take, and in what box to fit it in to give both the investors comfort, but also allow LISC the flexibility to really achieve what it was trying to do with the fund. And, you know, it was a great sense in a way of camaraderie and joint agreement on what the ultimate goal was. And so there was perhaps more flexibility in those conversations than what you'd be used to hearing, both because of the different nature of the different departments of the companies that were involved, as well as how the capital was going to be deployed, and both the liquid and illiquid nature of that. And then the other thing I would just note is, as the negotiation and conversations continued, there was a shifting among the different forms of capital vehicles that we're used to creating and forming, and the different terms to basically accommodate the different nature of liquidity versus illiquidity. And then a certain regulatory overlay that also came into play as time went on in fundraising and the basis on which the capital was going to be deployed.
In terms of what was the lawyer's role in setting up the BED fund, the lawyers had an extensive role. You know, first of all, I would say starting out that, you know, while we at LISC have lent to minority-owned businesses for a long time, one of the things we did with this fund was really do a deep dive into, you know, the challenges that Black-owned businesses, Black-owned financial institutions face. And, you know, just, you know, circling back to the what were we trying to address, you know, it became clear as we reviewed the most current research that the numbers were just like even more staggering than we would have thought. So, you know, recent study mentioned that Black-owned startups are approximately 3 times less likely to be approved for a loan than a white-owned startup. Another study that used Federal Reserve data indicated that a lot of Black-owned businesses don't even consider applying for a loan because they recognize that they're going to have a much harder time than a white-owned business. So the lawyers had to understand those issues, worked with our team in research and knowledge management, And one of the big things that we did together with Morgan Lewis is develop a special purpose credit program, which is a program that's permitted under a COA, specifically to allow, to promote access to credit to groups that have been excluded from it historically. And so lawyers wrestled with these issues from the beginning and helped set up the special purpose credit program, helped structure the fund in the ways that Miranda mentioned, address some, challenges along the way in terms of providing liquidity solutions and the like, which was important to meet the investor objectives, given that this was coming from their treasuries. So there was an important role for lawyers throughout the conception of the fund, and then of course executing it and working with the investors to bring it to life.
The lawyers were involved from the very beginning of kind of conceiving of the project and being involved in both the research of how, and all of this really starts with the ultimate deployment and the solution you're trying to effectuate. So starting from that point and almost going backwards to recreate a product then that could be sold to investors to invest in as an offering to help address that. So they were involved, LISC legal team was involved from the very beginning in helping to formulate that. And then they brought Morgan Lewis in to help further finalize the terms and structure of the product. So I categorize the areas of legal expertise that were involved in two main categories. And the first, and really actually both of them fall into the overarching theme of flexibility, which is I think so often the case with these impact investment funds and the effect they can have is flexibility to accommodate the ultimate goal of what you're trying to achieve and then the investors that are participating in it. So initially, the first topic being the flexibility of terms, right, to accommodate the public nature of the investors and the Treasury departments that were approving and being involved in the investment. And I think, the strategy of really Treasury fundraising and the Treasury function, which would typically invest unused cash on a balance sheet of a public company in high liquidity, low risk investments, and really being able to utilize those balance sheets in an effective manner to effectuate social change was a really innovative tool on behalf of the business team at LISC, and then how to accommodate those. So the legal expertise involved was to really pull, in that instance, from more liquid forms of investment vehicles and standard terms that investors would be comfortable with, and then augment them extensively with other examples from illiquid and permanent capital type of vehicles. Layered on top of this, it's really a debt strategy. So in addition to kind of meeting the needs of the Treasury departments and the investors that were making the investment determination, it was also layering on debt-like terms of different debt funds you would see in the market, and then whether and to what extent they would continue to be appropriate in this instance. So it was kind of a combination of all of those items. And then the second thing I would just note as being kind of the second area of expertise, which Bob had made reference to, was LISC's unique solution to reverse discrimination concerns that could arise from an investment strategy that was targeting deploying capital on the basis of a protected class, such as race. So LISC has decades of experience investing in people and communities that are underserved and low income as a CDFI, and in addition, kind of added a new tool to its toolkit about deploying the special purpose credit program under the Equal Opportunity Act, or a COA, as we refer to it. And, a COA prohibits creditors from discriminating against applicants on the basis of race and other protected characteristics. However, there's an exception for certain special programs that can be administered to economically disadvantaged classes of persons to address some sort of special social need that meets standards that are prescribed in Regulation B and by the Bureau. And there these special purpose credit programs are important for a variety of reasons, but mainly they're expressly permitted to require that recipients share the same race or other protected characteristics without violating a COA. So the fund was actually able to effectively target the historical denial of credit to Black Americans and their access to credit on less favorable terms than other groups. And the last thing I would just note is that the other huge benefit of a COA was that, and the fund qualifying as a special purpose credit program, is it addresses the risks of violating civil rights era laws such as Section 1981, which prohibits entering into a contract on the basis of a protected class such as race. And providing contracts or grants with contract-like elements solely to Black-owned or Black-led businesses poses a great challenge under Section 1981. But here, ACOA's anti-discrimination statute supersedes Section 1981 because it was enacted after, and its provisions regarding special purpose credit programs are much more specific. So we were able to kind of address an overlying risk of all of the different types of investment vehicles that are being created right now in the marketplace, and do so in a manner that got everyone comfortable that we could proceed with the special purpose credit program and really have, you know, a great ability to effectuate change in the way that LISC was seeking to do so.
I would say there was a range of areas, legal areas that were involved and that we drew from. So there was, you know, traditional lending issues because the purpose of the fund is to lend, and since they're lending to an historically disadvantaged group, there are issues to consider around discrimination, which ACOA, of course, was passed to prevent. But there is the special purpose credit program, with which both Miranda and I previously mentioned, which does permit and in fact encourage lenders to set up in order to, you know, address some of the unmet and unaddressed needs of minority communities. So there was an very interesting analysis around ACOA and the special purpose credit program and Section 1981 and some concepts really even from labor law that have a bearing on discrimination in the workplace as an analogy to discrimination in lending. So there was an extensive amount of work done in that area. And then of course there is structuring and setting up the fund, which is a complicated endeavor with sophisticated investors, which we did have. And again, the fund was not not that any fund is off the shelf, but this was particularly challenging because we were trying to meet the needs of the Treasury strategy. And so, but at the same time, we needed to know that we were, you know, going to have the funds for a period of time and able to deploy it and make sure that we could achieve the impact that we wanted to achieve. So there was a lot of, I would say, a lot of different areas of the law that were involved and that came together in the conception and execution of the fund. In terms of my final comment, I would say that we at LISC know that a lack of access to credit, in particular with small businesses, is a major contributor to the racial wealth and income gaps that we see, and that, you know, this is a big challenge that we and other CDFIs face and other mission-oriented lenders. And, you know, coming up with programs like the BED Fund, you know, together with Morgan Lewis, who is just so critical to making this happen, is just really important. I mean, we really have to, I would say, as an industry and as a group of financial institutions that want to achieve social justice, have to keep thinking outside of the box to try to find ways to develop programs to address these racial wealth and income gaps. I mean, we all know that how important it is to address these, and it's been, you know, painfully, we've all been made painfully aware of it over the last year or so. And I just think it's really important for all of us to up our game in this regard and to extend ourselves to do what we can to make sure these programs come into being and get the capital to these businesses and entrepreneurs who are well deserving. And so I'm hoping that the BEN Fund will be just the start of that. I know there's other worthy programs that are out there, but hopefully the BED Fund will contribute and we'll see an acceleration of more programs like this.